Crossover matter, serial number 24, MA number 408 of 16, Mr. DC code for appellant, Mr. Suraj Singh, Mr. Ithiti Sinha for respondent.
No one appears on behalf of the appellant on second call. 4 weeks.
Serial number 32, MA number 328 of 80, Mr. Amar Kumar Sinha, Mr. Sandeep Verma for appellant.
First half में नहीं है. Same order.
Under the heading for hearing, serial number 37, MA number 95 of 50, Mr. DC code for appellant, Mr. Nitin Ranjan for respondent.
Where is Mr. DC Ghosh?
I have not been able to contact him. He has contacted me after the vacation. Since I was also not here, I don't know where is he. Otherwise, he would have conveyed me something. I don't know what is the difficulty he is facing nowadays. Okay, in the evening, today evening, I will try to contact him and ascertain what is the reason.
No one appears on behalf of the appellant. Adjourned for a week. 1 week?
This is good, but may I say something? And in this case, Mr. Councillor acted time for seeking permission for withdrawal on last few occasions.
But I don't know, I have no instruction over
He is
it.
not there.
I have no instruction over it. So DC Ghosh would be in a better position to say. You are not the, I am not the concerned at all.
Think about it.
Serial number 38, MA number 224 of 50, Mr. Harpreet Kumar Lal for appellant, Mr. Rohit Ranjan Sinha for respondent.
Where is Mr. Arvind Lal? एक केस था ना उसमें नहीं आया था. Earlier there was another case in the admission. Mr. Arvind Lal. Where is he?
Well, he is here. He is here. I have seen him.
Pass over.
Serial number 39, MA number 162 of 60, Mr. Alok Lal for appellant, Mr. Saraswati for respondent.
Well, in this case, I am challenging my liability on the ground that on the date of said accident, this Tata Sumo Victor was not registered. So therefore,
Not registered.
Not registered. We won't be any of the registering authority. Now, in this case, the fact of the case is not much in dispute. That one person got down from Matador and was dashed by this Tata Victor Sumo. Now,
It was a new vehicle.
it is a new vehicle. The date of accident, my lord will file, is 14/6/2005. And the
14/6.
14/6/2005.
And the insurance is?
Insurance was there because one of the prime criteria for registration
Registration
is
it has to be insured.
insured. Now, I am coming to that. This was insured on the LCR might be here, but the date of insurance is
Date of accident is?
yes. Date of accident would be the relevant date. In this case, the date of accident is 14/6/2005. It was registered on 2/9/2005.
2005.
Therefore, on the very date of accident, this was not insured. And this was insured as,
What is the certificate of insurance?
yes, certificate of insurance would be Exhibit X by 1 and Exhibit X is the certificate of registry. Now, these two documents supports that on the very date of accident it was not.
It was not registered.
It was not registered.
So
Therefore, at the best, I can say the principle of pay and recover would apply.
why pay and recover?
As because there was insurance, but this is the normal practice is being followed. The liability in this case, at the best,
You were liable to indemnify the owner.
owner
Now the question is the vehicle was not insured.
not insured.
It's a penal offence under the MV Act.
MBA. Now,
So
apart
he
from
will, the penalty will follow.
Like,
How
apart
can you
from
say that I will not?
no, apart from that, I'm coming to that. I'll be satisfying your lordship with some of the judgments of our own High Court on the same issue.
Yes, show me that.
Yes. Well, and other High Courts also, your lordship.
Show me that.
This our own High Court is miscellaneous appeal number.
This is the only ground.
This is the apart from that, this was insured as, I'm coming to that, insured as passenger carrying vehicle. Therefore, he should have produced the permit also. The permit was also.
No, what do you mean by passenger carrying vehicle?
Yes, the insurance was, can you see the policy of insurance? Policy of insurance.
This is a passenger carrying vehicle.
It's a passenger carrying vehicle, but
Your car is also a passenger carrying
my
vehicle.
passenger carrying commercial vehicle.
No, is this a for the commercial vehicle?
Yes,
Show
the
me.
policy may kindly be seen. The policy may kindly be seen. At the head of the policy.
Certificate of insurance of passenger carrying commercial vehicle.
Commercial vehicles. Therefore, in such circumstances, the permit has to be there.
Show me the provision of permit and under which provision.
Section 66.
You read that.
Necessity of permits. No owner of a motor vehicle shall use permit or use the vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying passengers or the goods, save in accordance with the conditions of permit granted, countersigned by the regionals or the state transport authority or any authority prescribed in the law, authorizing him to use the such vehicle in that place in the manner in which the vehicle will be used. So therefore, owner has not produced any permit. Had it been the private vehicle, there was nothing like that. But they got it insured with a personal carrying commercial vehicle. They have paid the premium for that. Therefore, they are bound to produce the permit. They are bound to carry the permit. And over and above, it was not being applied with a valid registration. And on this issue, I am relying upon some of the judgments, which is of our own High Court and of other High Courts also, and the Honorable Supreme Court also. The Honorable Kerala High Court, in such a similar situation, has held that it is not a technical breach, it is a fundamental breach. That will be the constitutional judgment of the Honorable Kerala High Court, 5 cases. What are the 5? These are the judgments which I am relying upon.
Permit was not produced.
Yes.
Permit was
Permits were also not produced. No registration, that is apparent from the RC book.
Who is appearing? Who Who is the owner?
Some appearance has been filed. I don't know what.
Where is Celebrity? Show me Kerala.
Yes.
Our High Court judgment.
ये देखिए.
Where is he? Let us see the issues.
Hello, in this case, my lord, I am just responding to order of
You are the owner of the vehicle.
but by mistake I have missed my file today, my lord. It was my mistake.
This 39, serial 39.
Yes.
He says that the vehicle, the registration was effected after the accident had taken place and there was no permit.
There is no question of permit, my lord. Because in view of Jharkhand motor vehicle rules, any vehicle having seating capacity less than 10 requires no permit.
You produce that certificate.
Whether it is commercial vehicle or private vehicle.
Yes.
whether it is a commercial or private, rule permit is not. Kindly see rule 70 or 71.
Jharkhand motor vehicle rules.
Actually, my mother-in-law died 3 years ago. My daughter went to that. Yesterday I came.
Take a turn.
You want tomorrow?
Yes,
Next
yes,
week?
Tomorrow day after tomorrow. But I am not ready. If you want to get, I am ready to ask without my.
ठीक.
And what about the registration?
Registration is not a condition precedent for issuing the insurance policy. Insurance policy that time was being issued at the time of delivery of the
Listen
vehicle.
to me. The Act provides that without a vehicle being registered, you cannot ply.
But earlier,
What is the nature of that default? If you default, what is
that
the
may be
nature?
traffic violation. That may be traffic violation. And if any case was registered before the police, the traffic violation section has not been implicated. कि रैश कंडक्टर चला जाता है तो 279 से 38 से 37 चैनल 4 का केस होता है। इन अंडर द मोटर व्हीकल एक्ट जो है,
See, there is a breach of law. So you mean to say there may be a breach of a provision of law which is not a breach of a condition of policy?
yes,
Show me. इसी में आप
under the policy, nowhere it can be mentioned that without a citizen vehicle cannot drive. In the entire road policy, it has not been mentioned. There are so many government vehicles here, more than for the last 10 years, 20 years, without registration they are being applied.
That has been taken care not only by
Very correct.
the court also.
Very correct.
Note of the court also.
On last occasion.
Yes.
In the entire policy, my lord, our entire IMT clauses, India Motor Tariff clauses, nowhere it has been mentioned that if the vehicle is not registered, insurance company is not covered. If it is so, I am not covered.
This means that a person, after buying a vehicle, getting it insured, may apply without a registration, without the policy, without the private.
No, he may apply it. See, one is the penal consequence as per the Act.
But
As per the Act. Another
But-
is the breach of condition of policy.
Breach of the condition of the policy.
You
Yes.
show me that it is a breach of condition
Right.
of policy.
Now, in this case, Lord, my answer would be the judgment of Honorable Kerala High Court, which I have cited before your authority, that has discussed this aspect also. That Constitution 5 days, Honorable 5 days, it has discussed these things. Specifically, these things are discussed. Are discussed.
there may be Kerala rules. I have got the Kerala rules.
Yes, you might have everything.
Yes.
You have to something very, but I don't
State
have-
wise
One
rules
is the
are
Kerala
changing.
judgment.
Last one, the Parit Bill, that is Supreme today. Parit Bill.
Is this?
With pencil, I have made some notes.
This is flying without a permit.
All these things are there. Right, without permit, fitness and everything. That is not a technical breach, it is a fundamental breach. Now, the Narendra Singh.
Now tell me what are the conditions of policy? What are the conditions of policy? Then I will see that whether there is a
In this
breach or
case,
not.
but the first and foremost thing is that before getting the vehicle registered, one of the prime conditions is that it should be insured. So that insurance is there, presumably that the owner, the insured, will get the vehicle.
Have you mentioned in the policy
Just
that if you drive this vehicle without getting the same registered, this policy will not be effective or it will be treated to be a violation of the condition of policy?
now, if we come to the policy itself, What
Show me the
would
policy.
suggest?
First of all, you have not exhibited the policy.
The policy is there. Exhibit X by 1 is there.
What is X by 1?
That is the schedule.
Is it the policy?
That
Is
is the
exhibit X
schedule.
by 1 the policy? There is a difference between a policy and a certificate. What is X by 1? X by 1 is a policy or a certificate? It's a certificate of insurance.
Certificate of insurance. So,
So
certificate
does it
of
contains
insurance-
all the conditions?
Well,
So
that-
rely on this. If you say this is the entire thing,
Well, I have to see what is that now? What is this? Now, what is the specific condition in this? He says that policy covers only the use and permit within the meaning of the Motor Vehicle Act or such carriage falling under the subsection 3 of the 63 Motor Vehicle.
yes,
This is the policy of this is one such policy condition.
yes.
Now, the other, of course, subject to the consideration of the person, driver's clause is there, but
You show me that on happening of this event or on non-happening of this event, this policy is not.
but the conditions of permit is there. The condition of permit is there.
Where is it?
That is in the
Where is it?
policy schedule itself. It is mentioned. Over.
Show me.
The limitations as to use. Limitations as to use.
Page. Limit of liability.
उसके ऊपर, just above that,
Policy covers
only under a permit within the meaning of the Motor Vehicle Act
yes, yes.
or carriage falling under
Then
section.
policy do not cover. In policy do not cover organized racing,
हाँ, वो नहीं है, उसके नहीं
So
इसमें
making
cover.
reliability, so and
हाँ,
so.
उसके
speed
just above that,
testing
just above that,
While using,
just above that.
yes,
The policy covers only used only under permit within the meaning of subsection 3 of section 66 of the Motor Vehicle Act.
okay. He says the permit is not necessary.
Yes, ma'am. Permit is required under section 66 of the Motor Vehicles Act.
But where is the exemption for this? मतलब the section
You are
subsection
relying on
Rule 70 of the Jharkhand Motor Vehicle.
2001,
but
Yes.
that is
Earlier it was Bihar Motor
Yes.
Vehicle.
not
Same.
side by side. 70.
Yes.
Read 70.
what is the limit of that use? Scientific self-organization. That is only for rural areas. This is also significant to know. That is for the rural areas. Section 66 has exceptions also. But this vehicle does not fall any exceptions. What is the exception on section
Section
66?
70.
70.
Read 70.
अभी गलती से नहीं ला सकते इसी में Section 66 is the requirement of the
Restricts the provision of subsection 1 of section 66 shall apply to any motor vehicle constructed or adapted to carry more than 9 passengers, excluding the driver.
But for which area? That is also there.
There is no area.
I'm coming to it. Let me.
Any endorsement in this policy that without the same being registered, if it is driven, the policy will be treated to be void, or it will be deemed to be the violation of the condition of policy.
So far, on the point of registration is concerned,
I am on the point of registration. First satisfy on the
on
point,
the point of registration, there is no such condition mentioned in the policy. But by various pronouncements of the Honorable Supreme Court,
Show me the Supreme Court judgment.
that under similar. That is second one. Of course, there is no such condition mentioned in policy that without registration it would not be valid.
What do you say about the Narendra Singh judgment?
I'm not gone through that. Not even considered.
Here.
Then day after tomorrow is
Mr. Alok
Not
Lal-
have to already come on next.
Mr. Alok Lal submits that the offending vehicle was, though registered with the appellant, though insured with the appellant, yet was being driven without the same being registered with the registering authority. He submits that this
On the date of accident.
on the date of accident. He submits that this is a fundamental breach of the terms and condition of policy. That being so, the insurance company should get the right to recover the amounts of compensation from the owner of the vehicle concerned. He relies upon the judgment of the Honorable Supreme Court in the case of Narendra Singh versus New India Assurance Company Limited, within brackets civil appeal number 8463 of 2014, arising out of SLP within brackets civil number 26308 of 2013. Narendra Singh क्या ना? Decided on 4/9/2014. Next, at this stage, Mr. Arvind Lal, learned counsel appearing on behalf of the owner of the vehicle, prays for some time to go through the judgment of the Honorable Supreme Court and address this issue. We'll stop. Next line. Is this case after 1 week?
In this case, my lord, my prayer is let it be after 15th of this week. And because my mother-in-law has died.
2 weeks.
2 weeks things.
2 weeks.
So said that
Prays
this
for
was
2
time
weeks.
to go to that.
Prays for 2 weeks time.
Right.
Under those
The citation declared by SSC. Narendra Singh. Versus.
I cannot forgive I am sorry, my lord, नहीं आ सकता.
30?
31 case.
Wait, it was possible.
Serial number 40, ML number 262 of 60, Mr. Izzuddin Sinha for appellant, Mr. Prince Bihari Sinha for respondent.
It's appeal under section 30 of the policy.
it's one mistake. But you must inform that they got the entire amount.
That you were saying from the day one. It was admitted very recently.
Yes, it was that.
He has received the amount.
Yes, total.
Mr. Prince Bihari Sinha prays for some time. Prayer allowed. Is this case after 4 weeks? Is the case where he died?
Due to sunstroke,
Sunstroke.
the substantial question of law is that the Employees Compensation Act covers the death arising out of in course of employment due to accident. The normal death arising out of in course of employment is not
Whether
covered.
this is an accidental death or a
Whether
It is an
sunstroke is an accident or not. I am relying on the Supreme Court judgment that sunstroke is not an accident for the purpose of insurance.
That they what they or because of the lubricant or the chlorine.
Because every accident during work hour is not covered under it.
after 4
If
weeks?
any disease was communicated due to nature of job, the schedule is there. But sunstroke is not provided in schedule, and number two, sunstroke is not an accident. It's a normal act. That if a sunstroke happens, it occurs. And therefore, the Honorable Supreme Court relied to the judgments of the Supreme Court of America and others have held. Even the malaria, it is not arising out of it. All right.
Serial number 41, ML number 105 of 70, Mr. Pradeep Kumar Devmani, Mr. PC Rajaran for appellant, Mr. Kamdev Pandey, Mr. Ganesh Ram for respondent.
Today, fortunately enough, the counsel for the respondents are appearing on the respondents.
Yes. This is probate.
Yes, it's arising out of a probate case,
Yes.
and the brief facts of the case is like this, that the appellant and all the respondents are the children of one and the same mother. The mother executed a bill in favor of the appellant in respect of certain property, landed property. And respondent number 1 is the only respondent who contested the case. Others offered their no objection in the court below also, and here also they have offered their no objection by way of counter affidavit. Now, the learned trial court has rejected the suit only on two technical grounds. Firstly, that the section 68 of Evidence Act, requirement of section 68 of Evidence Act has not been met, and secondly, the requirements of Section 281 of Indian Succession Act has not been met. Thus, on earlier occasions, I had shown to your lordship that both these grounds were not available to the London trial court. However, it has been taken erroneously and illegally.
Why?
Lord, Section 68. What does Section 68 says? Lord, may I be permitted?
Yes, let us go to Section 68.
68. It says about the requirement of examining an attesting witness is a document
Just a minute. 68.
Yes.
68 of the
Evidence
Act.
Act.
Evidence Act. If a document is required by law to be attested,
It shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution.
the will was attested.
Yes,
There
it
was
was
attesting
attested by
witness.
3 attesting witnesses.
They had not appeared before the court.
No, that's one of the attesting witness, PW3, has already been examined in this case. And even then, the London trial court says that the requirement of Section 68 is not met. PW3 is the attesting witness Ranjit Kumar Verma. He is one of the attesting witness in the bail. PW3. But the numbering of the witnesses is erroneous in the lower court record. So on the earlier occasion also your lordship got confused due to wrong numbering of the witnesses. Its name, if your lordship may have a look, to the deposition of Ranjit Kumar Verma.
Ranjit Kumar Verma.
Yes.
This is an unreasoned order. What sort of order is this, Mr. Counsel? What sort of order is this? What is the reasoning? Argument, case of the plaintiff, case of the defendant, argument of the plaintiff, argument of the defendant, proposition of law, conclusion, 2 issues framed, and where is the decision on the issues?
But I therefore one can mention.
Why? What will you say? This is a non-reasoned judgment. This is not at all a judgment. What is 281 of the Indian Succession Act?
Yes. That. Is about verification of petition for probate by one witness to the will.
So,
Where the application is for probate, the petition shall also be verified by at least one of the witnesses to the will when procurable in the manner or to the effect following, namely, I, CD, one of the witnesses to the last will and testament of the testator mentioned in the above petition, declare that I was present and saw the said testator affix his signature or mark thereto, or that
what do you say about this?
Lord, verification was not there in this case. But Lord, my submission before Lord is that Lord Ranjit Kumar Verma is one of the attesting witness, and whatever he was required to say on verification at the time of filing of the claim, he has already said in his deposition in this case. And moreover, one judgment I am relying, Lord, of Madhya Pradesh High Court, which says that if the section 281 requirement of section 281 is not met, on these grounds suit cannot be dismissed. It can be the learned trial court out to have directed the plaintiff to remove this anomaly. For that purpose, the suit cannot be dismissed. So this statement has relied. If your lordships may kindly come to the last page, lords. Last page, second paragraph.
Yes. Yes, Mr. Counsel.
That person in number 15
Yes.
is qualified and formulated.
Yes. Now, where is the answer to this point?
Whether the bill dated 14/12/99 question is valid or not.
Where is this? Where is this?
There is no
What is the
fighting
answer
on
of
this
this issue?
That is another anomaly.
See, you admit up to paragraph 20, he only cut copy paste the argument and the case. Then paragraph 21, he frames two issues. Where is the answer of these two issues?
In fact, the learned trial court did not go into these questions, and only on the ground of section 68 and section 281, the case has been discussed.
Yes.
The issues have been there lastly have been and thereafter it has been answered.
Where? Whether the will dated so and so is genuine or not. This is the issue. Show me the answer.
Paragraph number 22, there is stated about here, since the will has not been certified or certified by this is considered as required under section 68 of the.
Where? From where did he get this?
There is no
It has not been validly executed by Dishi Shanti Devi as required under section 68 of the Evidence Act. What does Evidence Act doesn't say about execution of the will?
Yes.
Evidence Act says that this should be
how this such
proof
document can be
in a
proved.
what manner?
Yes.
The manner of proof. Section 68 of the Evidence Act doesn't say about execution of a will.
Exactly.
It says about proof of a document.
Yes.
So this part goes. Yes. Pick up. Heard the learned counsel for the appellant and the learned counsel appearing on behalf of the respondent. The counsel for the appellant submits that the judgment imputed is cryptic and lacks reasoning. He submits that even the issues which have been framed has not been answered by the court. He submits that in the most mechanical manner the probate application has been dismissed. The title suit, the title suit 3 of 2004 arising out of probate case number 5 of 2001 has been dismissed. It submits that the judgment thus is perverse and needs to be set aside. Next one. Then it counsel on behalf of the appellant submits that the court in paragraph 22 of the judgment has held that the will was not validly executed as required under section 68 of the Evidence Act. He submits that the application was also not signed and verified by the attesting witness under section 281 of the Indian Succession Act. Thus, the application was dismissed. After hearing the parties, I have gone through the judgment of the impugned order. The least it is said about the impugned judgment is better. The most mechanical manner without application of mind. The District Judge 2 Giridi has disposed of title suit 3 of 2004, which arose out of probate case number 5 of 2001. A will was next one. A will was executed by Srimati Shanti Devi, wife of late Sundar Singh, who happens to be the mother of the appellant petitioner and the respondents. The will was executed in favor of the appellants. Thus, the appellant filed a probate case. Filed an application for grant of probate. The contesting respondents, who happens to be, was respondent number one, who happens to be the brother of the appellant, and opposed the said probate case, which was numbered as 5 of 2001. Thus, the same was converted to Title Suit 3 of 2004. The trial court in paragraph 1 and 2 of the judgments refers the fact of execution of the will and conversion of the title suit, probate case to a title suit. In paragraph 3, of the judgment, the trial court noted down the plaintiff's case. Paragraph 4, the trial court, the trial court noted the case of the opposite party number 1, who is the contesting respondent. Paragraph 5. In paragraph 5 of the judgment, the trial court frames 2 issues which are as under. Paragraph 6 of the judgment. In paragraph 6 of the judgment, the trial court only mentions the name of the PWs 1, 2 and 3. Paragraph 7 of the judgment, the trial court mentions what were the exhibits. Filed by the plaintiffs. In paragraph 8, the trial court mentions the documents which has been exhibited by the defendant, and in paragraph 9, the names of the
documents were filed by the petitioner itself but could not be exhibited. In paragraph 8,
exhibit 3, 1, 2 and 3.
Yes, Milord, in the paragraph 8 also, these are the documents which had been filed by the petitioner.
So paragraph 8, the trial court mentions some of the documents which were filed by the plaintiff but could not be exhibited.
Yes.
Paragraph 9, the trial court only notes the name of the defendant witness. Be it noted that none of the documents or the oral witnesses were discussed by the trial. None of the documents or the gist of the evidences of the witnesses have been discussed in these paragraphs. In paragraph 12, the trial court notes down the argument which was advanced by the plaintiff. Similarly, in paragraph 13, the argument on behalf of the defendant has been extracted. In paragraph 14, the trial court notes down the provision and extracted the provision of law, that is paragraph 14, 15, 16, in paragraph 14, 14, 15, 16, 17, the trial court notes and quotes the provision of law, that is Section 276 of the Indian Succession Act, Section 281 of the Indian Succession Act, Section 68 of the Indian Succession Act, 68 of the Indian Evidence Act, 17 तक आया. In paragraph 18, the trial court only notes the citation relied upon by the defendant. (18) and 19 notes the citations relied upon the stuff. 20 कहाँ किया? And 19, 18, 19, 20 citations. 3 citations relied upon by the defendants. Thereafter, a heading conclusion was typed in the judgment, and under the said heading, in paragraph 21, the issues which the trial court framed earlier was quoted again, and thereafter in paragraph 22, the following has been held and the case was dismissed. Paragraph 22 quote. Next one. This is the manner in which a probate case was dealt with by the trial court. There is no reasoning as to why the court came to such a conclusion, nor the issues which the court has framed has been answered. Further, I find that the court has relied upon section 68 of the Evidence Act and held that the will was not validly executed as required under 68 of the Evidence Act. Full stop. Section 68 of the Evidence Act deals with proof of execution of document required by law to be attested. Full stop. The will is exhibited as Exhibit 1. It contains the signature of one. What is the name?
Ranjit Kumar Verma, Purushottam Kumar Mishra, and Suri Narayan Verma.
Where is it?
On the first page, notes.
पढ़िए.
First name Gawar Ranjit Kumar Verma, and second
कहाँ? Where?
Notes. This.
नहीं, सर्टिफिकेट को भेज दीजिए. यहाँ तो नहीं दिख रहा है. This is typed copy ना. Witness पुरुषोत्तम.
नहीं, टाइप कॉपी नहीं होगी, वो हाथ का ही लिखा हुआ.
हाथ से लिखा हुआ है ना. This said
Ranjit Kumar Verma, Purushottam Kumar Mishra, और Suri Narayan Verma. These are the attesting witnesses.
Who is the person? Ranjit Kumar Verma. The
Yeah.
said will contains the said in the said will there is a signature of Ranjit Kumar Verma as a witness, who is also PW
3. In the trial court record, it is recorded as PW 5.
who is also a witness. Witness bracket में लिखो shown as PW number 5.
5, yes.
But though there are only 3 witnesses.
Only 3.
And we have 4 witnesses. Whether this signature is a proper attestation or not is also a subject matter which the court should have decided, but he failed to do so. Further, I find that the court has held that the petition was not verified in terms of section 281 of the Indian Succession Act. 281 of the Indian Succession Act. Whether provision of section 281 of the Indian Succession Act is mandatory or not has also not been gone into by the court. As the learned counsel appearing on behalf of the appellants submits that in view of the judgment passed by the Honorable Madhya Pradesh High Court in case number so and so, if an attesting witness doesn't sign an application, the same cannot be said to be an absolute bar in filing the probate case. But be as it may, I find that neither the issues were properly framed or answered, nor the court has given its finding on the issues, which makes the entire judgment perverse and illogical. So this judgment thus needs to be set aside. First of all, I therefore set aside the imputed judgment dated so and so passed by so and so, and remand the title suit 3 of 2004 before the District Judge Giridi for proper decision afresh after framing afresh. This appeal stands alone. The parties are directed to cooperate. ये जजमेंट बाद में ले लीजिएगा.
जजमेंट रद्द किया गया.
The court records is sent back to the court below. It is expected that the trial court will pass a fresh judgment, reasoned judgment, considering the evidence on record within a period of 3 months from the date of receipt of the copy of this order.
Passover matter, serial number 38, MN number 24 of 15, Mr. Arvind Kumar Lal for appellant, Mr. Vaidyanathan Sinha for respondent.
This is for vehicle is not insured. Again, customer of the
You are the claimant.
I'm the claimant.
Vehicle not insured, so
So therefore, insurance company is
Both
not.
vehicles were not insured, madam, and on last occasion, Mr. Kumar Sinha intervened in a matter and he took time to seek instruction from the owner of Tata 407. As earlier, Mr. Sumit Kumar used to appear.
so there are other lawyers also. Proceed, yes.
But not, the income is 4,000 rupees of the deceased, and it was rightly given 10% future prospect not allowed because it was 50 years.
What is the age of the deceased?
50. Court has
50.
considered 60 in postmortem, it is 50 years. So between 50 and 60.
Between
50 and 60. Postmortem 50 years, court considered 60 years. 10,000 rupees per consortium and estate has been given. My case lies in a very narrow compass. But
What was your income? 4,000.
4,000. It's still there.
Your claim was 4,000.
Yes.
The court considered 4,000. So what more you need?
For future prospect,
Only future prospect.
future prospect and consortium estate, only 10,000 has been given.
So 60,000 there.
Yes, ma'am.
And 10% means
4,000 ka 10% transfer.
$400.
400. 4,000 का तो 400 हो जाएगा. तो 4,400 में
ना कितना आएगा? Who are the dependents? Dependent क्या है?
ये wife and one child and ये mother.
हाँ?
Mother. He.
Mother. What is the age of the child? The date of the accident? इंटरेस्ट तो बहुत दे दिया, 9% दे दिया। तब
सुप्रीम कोर्ट में क्या होता है 9% का भी जजमेंट आ रहे हैं, 7.5 के भी आ रहे हैं, 6 के भी आ रहे
नहीं, अभी जो the position in the economy it is
हैं। और
7%।
का भी है तो और इंटरेस्ट
2% ज्यादा हो गया, 2% तो मिला जुला के एक ही हो जाएगा।
एक ही
तो इसको क्या
बोला
करें?
इसमें तो अब तो चूंकि इंश्योरेंस नहीं है तो लास्ट टाइम में माइनॉट ने कहा था कि
नहीं तो आप रिकवर कर लीजिए उससे।
रिकवर तो करेंगे, लेकिन चीजें का अगर एमिकबली अगर मान जाए तो कम बेसी होकर सेटल कर लेंगे। इससे ज्यादा क्या पूछेंगे आप?
कितना मिला है? 3,62,000। तब
The condition of my client is also not.
I don't. There is an order you have to pay. You have to pay.
7 years old child of 4,60,000 का was
Claimants claim that fault was of the driver of Tata Motors. He not claim of it.
That you cannot take into account.
I also tried before the National Lok Adalat, but they were not able. देखिए जो इंश्योरेंस नहीं रहते उसको तो गाड़ी को रिलीज करना ही नहीं चाहिए था।
$3,87,70 कितना होता है?
मतलब
3,87,70
455.
हम्म?
455. 457. 457.
4,57,000 होना चाहिए। 3,62,000 हुआ है।
95,000.
कितना हुआ? 4 लाख 4
457.
$95,000 का डिफरेंस है।
My client is in a position only to comply the order. He is not able to. He will not be able to pay anything more now.
How much is?
Even
दोनों गाड़ी में
Yes, ma'am.
yes, ma'am.
and both have been saddled with that.
Yes.
50-50 किया है।
50-50.
50-50 तो दीजिए, तो बड़ा को दीजिए। 95,000 का 50-50 दीजिए। टोटल टोटल हुआ है कहाँ where is the 50%? 50
last page of the Indian automatic page 8 awarded
4,57,000 हो रहा है ना?
Yes.
25 तो 27
हाँ?
तो 28 2 लाख
2,28 2,28,500 2,29 बोलिए कितना दीजिएगा?
My instruction is that he will not be able to pay some matter. He is a farmer and he is doing nothing.
गाड़ी कहाँ रखा है बिना इंश्योरेंस का?
He is receiving the old age
बेचिए
pension.
जमीन अभी होगा
अगर फार्मर कहेंगे भाई तो पंजाब का फार्मर जो
ना,
स्टाइल
पंजाब का
farmer.
स्टाइल के जब पूरा
वो
एसी
सब
ऑफ
मत
दैट
बोलिए। पंजाब का फार्मर वो पंजाब का ही होता है, कहीं इंडिया का कहीं नहीं होता।
उससे कम बिहार के और झारखंड के भी नहीं।
बिहार झारखंड ईस्टर्न रीजन cannot be compared. बोलिए you have to pay, Mr. Counsel.
We cannot escape.
Cannot shirk your responsibility. Tell me how much you will pay.
Maximum 50%.
हाँ तो 50% तो 2,28,000 आ रहा है ना, 2,28,000 इंटरेस्ट भी मिला उतना पुराना होगा।
2001 का
Settle भी you have not gone in for settlement also in the local law. लिखिए तो heard the learned counsel for the appellant, heard the learned counsel for the respondent. This appeal lies in a very narrow campus which is apparent from the
My two submissions will be done. One is that the claimant claimed that accident was due to fault of the Tata Port incident, and the charges was also on the driver of Tata Port incident.
It is not your appeal. He is only on the quantum. You cannot take all this quantum. The very narrow campus which is apparent from the argument advanced by the learned counsel for the appellant, Mr. Abdullah. Full stop. The appellant claimant has filed this appeal for enhancement of the quantum of compensation which has been awarded to them by judgment dated so-and-so past response. Since only the calculation and the quantum is under challenge and the appellant has prayed for enhancement, I am not entering into the other aspects. Next. The learned counsel submits that the future prospect has not been awarded, which should have been 10% considering the age of the deceased, which has been taken to be 50 years by the tribunal. He admits that the tribunal has accepted the monthly income of the deceased as claimed by the claimants, which is 4,000 per month. He further submits that on the account of loss of consortium and funeral expenses, 10,000 rupees has been awarded, which should have been 70,000 in terms of the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty and others. This is the only ground the appellant has raised.
Then one more thing, madam. Interest has been allowed from the date of award, not from the date of payment. Interest was allowed from the date of award.
He submits that the interest has been allowed from the date of the award and not from the date of the claim application. The counsel appearing on behalf of the owner of vehicle bearing number BR कितना नंबर है?
BHM 220.
BHN
BHM 220.
BHM 2205
etc.
Admitted that his vehicle was not insured. Full stop. He submits that the tribunal, he submits that though the charge sheet is against the driver of the other vehicle, that is BR12 6852, yet the tribunal has directed this respondent to pay 50% of the amount. Next one. Be it noted that both the vehicles which were involved in the accident were not insured. First off, the tribunal held that there was negligence on part of both the vehicles, thus apportioned the amount of compensation amongst the two vehicles. Be it noted that none of the owners of the vehicles have challenged the findings by filing an appeal. Challenge the findings which are against them, by filing any separate appeals. Also, in view of the aforesaid fact, the grounds raised, the argument of the learned counsel appearing on behalf of the owner of the vehicle cannot be looked into. Next paragraph. So far as the quantum is concerned, I find that admittedly the court has held that the deceased was 50 years and was earning 4,000 rupees per month. First off, in terms of the judgment of Pranay Shetty, 10% enhancement on account of future prospect should be awarded to the applicants. First off, next one. So far as consortium and funeral expenses is concerned, इसमें consortium कितना था? इसमें funeral expenses कितना था?
15,000 state and consortium public.
So Pranay Shetty is concerned, the claimants are entitled to get an amount of rupees 70,000 under conventional head, which the tribunal has granted conventional head, but the tribunal has only granted 10,000. Thus, 60,000 more must be paid to the claimants. The other factors, that is the dependent, that is the deduction on account of personal expenses, multiplier, etc., have been correctly assessed by the court, by the tribunal, which the parties also accepts. So, considering the aforesaid fact, the recalculation of the compensation amount will be as follows: 40 into 12 into 11, add 10%, so and so, less 1/3, so and so, add 70,000, so and so. The tribunal has already awarded 3,62,000. The amount, thus the balance amount is so and so. This balance amount should be should be paid at a proportion of 50:50, at 50% paid. This balance amount should be paid by both the owners of the vehicle at the proportion of, in the ratio of 50:50. Full stop. Next para. So far as the interest rate is concerned, I find that 9% interest has been awarded. Thus, I am not inclined.
From the date of award?
Yes, 9%. The rate of interest has been awarded as 9%, which according to this code is on the much higher side. Thus, I am not interfering with the judgment of the award. I am interfering with the award where the interest has been directed to be paid from the date of the award and not from the date of the application. Aforesaid observation, direction, this appeal stands. Find it out how much it is.
My lord is allowed interest from the date of application.
No.
Award.
Same interest.
9% interest from the date of the award. since it is 9%.